So welcome, and we're delighted to have Lady Dorrian with us again at Hay Legal, and she's kindly agreed to speak to us about the Scottish Sentencing Council's Death by Driving Public Consultation. So hello, Lady Dorrian, thank you very much.
Hello, good afternoon, Edith. How are you?
I'm well, thank you. How are you?
Yes, I'm fine, thanks.
So thank you again for agreeing to speak on this topic. I wonder if you might just start by telling us about the guideline and why this consultation is taking place.
Sure. Well, this is, as you know, we've done 3 general guidelines. Those are on the principles and purposes and the process of sentencing, both of which apply to all sentencing in Scotland, and the young persons guideline, which applies to all young persons. And we're moving from those general guidelines to the first of our specific guidelines dealing with specific offences. In this case, obviously, the statutory offences of causing death by driving, whether that be causing death by dangerous driving, causing death by careless driving, with or without being under the influence of substances and so on. This is our first offence one, and it's the first one that will actually have a range of sentencing possibilities included within it. And we have tried to follow the route of our process guideline and adopt a style that is clear, is easy to use for judges and sheriffs, but is also clear for the public to read and understand and to see at a glance almost what is involved in the process of sentencing for these kind of cases. So far as the question of consultation is concerned, we took an early decision that we would consult publicly on all of our guidelines. So that's the stage that we've reached now. In this case, we have carried out all our work to date on the guideline. We now have a draft, and we're putting it out for the public so that we can hear what views people have about what we're proposing.
Okay. So from the draft guideline, I see that there are certain steps for each offence. I wonder if you might just explain a little more about that.
Yes, sure. Well, according to our process guideline, you will recall that from that we say that the first step is to assess the seriousness of the offence. And that's really a combination of 2 factors, the harm caused and the culpability, the blameworthiness of the offender. Now, in these offences, the harm is always very high, namely that death has been caused. So the essential feature that has to be determined by the court still is the level of blame to be attached to the driver, the culpability of the driver. And so to help the court determine the level of seriousness, we've set out a number of tables, and we have a table that sets out in the guideline the possible levels of seriousness. They're grouped into groups A, B, and C. So to take, for example, causing death by dangerous driving, level A might involve a prolonged and deliberate course of bad driving with a disregard for the danger being caused to others. Level B might be driving that created a substantial risk of dangerous driving, and level C might be one single dangerous maneuver or other driving which caused a significant risk of danger to others. We've separated them out into factors which relate to the nature or manner of the driving, and then we list ones which relate to the capacity of the driver, and there are others which might relate to the knowledge of the driver, such as, for example, ignoring warnings from passengers, or driving knowing that a vehicle is defective, and things of that nature. The next step, once you've determined whether the seriousness falls into A, B, or C, is to determine the sentencing range. And we have another table that sets out what we suggest are the appropriate sentencing ranges for A, B, and C levels of seriousness. Obviously, in assessing the seriousness, it may be that you have several factors that come under C, and in that case, that might move the case up to B, or if you have a number under B, it might move it up to A. So you have to carry out a balancing exercise in relation to that. And the final table, in relation to each of these offences, is one that sets out possible aggravating or mitigating factors. These are not exhaustive, but they too are grouped. So we have those which relate to the consequences, those which relate to the record or to the circumstances of the driver, those which relate to the commission of other offences at the same time, and a mitigatory one for the reason for driving if it was an emergency. So those steps, they're all set out in the draft guideline, and they are all consistent with the approach taken in our process guideline. So that should help achieve consistency across the course of our guidelines.
Yeah, and I know myself that in these types of cases, very often I find, or practitioners find themselves referring to the English system. Is this a move towards being similar in approach to the English system that we've seen? Well,
in the sense that it provides a guideline, and that the Sentencing Commission in England and Wales has produced a guideline on this and on other subjects. Yes, I suppose in that sense, but only in that sense. There are two things to bear in mind here. One is that the comparison between the sentencing regime in Scotland and that in England, it isn't something that you can do completely directly, because there are, for example, there are certain sentences available there that are not available here, and no doubt vice versa. But also, we have decided to take a very clear and specific approach ourselves, starting from our principles and purposes guideline and our process guideline, and working that through the offence specific guidelines. So in the sense that you could always draw a comparison between any system where there is a guideline, you can draw the comparison, but beyond that, I think this is a very clearly developed guideline specific for Scottish circumstances.
All right. So what issues then are there with the current sentencing situation for death by driving cases?
Well, as you will be well aware, Edith, these cases are really difficult. They're very complex to sentence. They're very serious. They have a very high public interest, understandably. They are particularly difficult for judges and for sheriffs, because the culpability can range hugely from one end to the other. So you can have something which is, as I was suggesting earlier, a prolonged, deliberately chosen course of bad driving, maybe involving racing on a public road at one end, and at the other end you could have a moment's inattention by a driver with a previously good driving record that ends up causing death as a consequence of a single careless action. So that makes it very difficult, and in particular causing death by careless or inconsiderate driving without any aggravations or without a substance element to it can be very difficult, because there is often a big discrepancy between the harm caused, which is the gravest possible, and the culpability of the offender. So we hope that the guideline will help people to understand that, because it's often not fully understood. It will be of use to judges and to sheriffs, because it will help them, identify the process to go through, the factors to consider, and really reach that balance that we have spoken about. But from the public point of view, to be important too, because it should help to enable the public to identify predictability of sentencing. It should help families and others to understand the nature of the offences and the difficulties that are involved in them, especially making the distinction between dangerous driving, especially top-end dangerous driving causing death, and careless driving, because that distinction, critically important distinction though it is one that's often not very well understood by the public. So we hope that the guideline will address both of these issues, the requirements of the judiciary, but also the public understanding, which of course is one of our main objectives.
Yeah, no, I can see that, and just because they're so emotive, these cases, they're just awful cases. You know, it's just often an instantaneous changing of many people's lives. So I can see that kind of education of the public can only be a good thing, and also just to give everybody clarity and consistency, because the guidelines are there. It's all set out very clearly as to what.
Yeah, I mean, we hope that the tables in particular will have that effect in helping the public understand not only how the factors creating seriousness can differ so radically between one kind of offence and another, but also what factors may be taken into account as mitigation or as aggravation, and helping to explain why the court in any given case may have taken the particular view that it did.
Yeah. So the consultation itself, what has that process been, in particular with reference to the public involvement?
Well, what we have done is we've obviously, it's all on our website. We have the draft guideline, or perhaps I should say guidelines, and we have a consultation paper that explains why we have taken the approach that we've taken, what we're seeking to do in each section of the guideline, what the purpose of using the tables is, why we have included certain factors as making the seriousness more or less, why we have included specific factors as aggravating factors or mitigating factors, how it may be that a series of determinants of seriousness of Group C, for example, could take the case up to a Group B or even a Group A, for example, causing death by dangerous driving. All of that is set out and explained in detail in the consultation paper, and we have also explained why we have suggested the ranges that we have suggested. So that consultation paper is the result, as is the guideline, of a process that has taken a fair period of time, because before we get to this stage, we always have conducted research into current practice. We've looked at statistics. We've consulted with the judiciary. We've done research on judicial and public perceptions in relation to the specific offence. We have worked with interested parties and had discussions with a range of victims groups, so to make sure that we have heard their views at the stage of creating the draft, and now we go out to consult the public at large on this. At the same time, we have to have a statutory consultation with the Scottish ministers and the Lord Advocate, and we're doing that at the same time. So we've embarked on both processes at the same time, and so the public consultation paper sets all of this out. It asks a number of questions, and we're seriously hoping that we get a lot of responses from members of the public and from practitioners. And in a way, that's where you and this interview come in, because we really do want to encourage practitioners to take part in the consultation exercise, which is open until late November. It's the 22nd, I think. We're also doing a webinar for practitioners on the 13th of this month, next week, and they can get details of that by contacting the Sentencing Council direct, and details of that will be given. We really do hope to get responses from the public. It's very important to us that we take into account what they tell us, and we're conducting a number of initiatives to try to make sure that people are aware of the consultation process and that they respond.
Yeah. No, we will promote the webinar that you mentioned for practitioners, which I think is, as you said, the 13th of October, with the consultation open until the 22nd of November, and just to encourage as many practitioners as possible to attend that. And yes, absolutely understand why that input is required. So we will put links to that alongside this video going out.
Good.
So what then is the process beyond the consultation, Lady Dorrian?
Well, the process beyond the consultation is we get the responses in, and we conduct an analysis of the responses, a very thorough analysis of the responses. We look to see whether they have come from individuals, whether they've come from specific groups. We look at how they may differ from one another. We look at what the rationale for the responses is. We then have a thorough examination of that amongst ourselves on the council. We do always look very carefully at the responses that we get and take into account what people tell us. If we accept responses that suggest that there should be changes, we have considerable debate about the nature of any changes that we should make to the draft before we do that. If we decide in relation to a specific point that we should not change the draft, we will explain that in due course. So we go through this process very carefully, going through line by line, really, the guideline, looking at what the responses have been, what the public attitudes have been, what the profession has said, and of course what our statutory consultees have said. We then we publish the analysis of the responses and our response to it, because we prepare a response that explains why we have or have not taken something into account, and why we have produced the final format of the guideline in the shape that it will be. And then we go through further process of refining the draft and taking the next steps for applying to the High Court for the guideline to be approved. So we're hoping that we'd be able to get this guideline approved next year by the High Court. That's the final step, obviously.
Yeah. All right. Well, thank you very much indeed, Lady Dorrian, for speaking to us. Encourage as many people, as I say, that can attend the webinar on the 13th of October. Yeah. We're very grateful to you again for your time today. So thank you very much.
The only thing I would say is I can't emphasize too much how we really want people to respond to the guideline. It's really important to us that practitioners and members of the public respond. So.
All right. Well, thank you again.
All right.
Thank you.
Thanks, Edith. Bye.
Bye-bye.